What happens if there's an order of the court and a person does not want to comply? Well, a couple of things can happen, and it depends where we are in the process. So let's say a person is ordered to pay a sum of money, $1,000, for a specific purpose. So $1,000 for the ABC purpose. Now, had that been litigated? Was it based on an application or a request? Were we in the middle of a case? I request the sum of $1,000 for ABC purpose. The other person, so there's going to be a, depending on the case, petitioner and respondent, or plaintiff and defendant, right? One starts with a P, pushing, and the other one starting with an R, responding, or a D, defending. Right, so plaintiff and defendant, or petitioner and respondent. So are we in the middle of the case? And the movement, like the applicant, I'm requesting $1,000. Did the answering party, did that party ignore it and let the order get ordered by a judge on default? Well, you don't have too much recourse in that instance unless you file something. Like, you can't appeal that, can't appeal the default, but maybe you can make a motion to re-argue or renew and say, I was not properly served, or I didn't realize the date, or I was ill, or I was incarcerated, or a circumstance that caused you to not reply. It may or may not be reasonable, and the judge may or may not agree with your second bite at the apple. Now, if an alternative would be, person asked for this $1,000, the responding person argued that, I don't have to pay it, I shouldn't have to pay it for this reason, doesn't make sense for that reason, it's inappropriate for some other reason, I don't want to pay it as a fourth reason, right? So there was some reply or response answering documentation. Now, if in the example that I've set up, if the judge orders the payment of the $1,000 anyway, well, that person that was not persuasive could appeal. That person could appeal to a higher court and ask that, even though there's judicial discretion, the person could ask the higher court to decide that the $1,000 was not appropriate based on one of the reasons. Now, if we take this all the way to the end of the case, and there's an order that a person is not satisfied with, not pleased with, it goes against their arguments, what could they do? Well, in that instance, if it was after a trial, an appeal could be taken. That's the subject for another day. If you don't like an order, you can't simply not comply. You have to do something in response. So it's ask a court to revisit it, to give a different reason or explanation. Can't be new evidence. It's a little complicated nuance. I don't know what should I start talking about that? Another video.